So a federal vaccination strike force may soon be knocking on your door, especially if you live in a community with low vaccine rates. Will the average person let them in? Probably. And if that's what they want, that's their right. And I believe in freedom of choice. But are you required to open the door? The Biden administration has announced it plans to send federal surge response teams, that's like a medical SWAT team, I guess, on a, quote, targeted community door-to-door outreach, end quote, to communities of low means. That's all fine and good as far as government propaganda goes, but nothing is ever as simple or as straightforward as the government claims, especially not when armed, roving bands of militarized agents deployed by the nanny state show up at your door with an agenda that is at odds with what Supreme Court Justice Louis Brandeis referred to as the constitutional, quote, right to be let alone. Any attempt by the government to encroach upon the citizens' privacy rights or establish a system by which the populace can be targeted, tracked, and singled out must be met with extreme caution. These door-to-door visits by COVID surge response teams certainly qualify as a government program whose purpose, while seemingly benign, raises significant constitutional concerns. First, there is the visit itself. And while government agents can approach, speak to, and even question citizens without violating the Fourth Amendment, Americans have a right not to answer questions or even speak with a federal agent. Courts have upheld these knock-and-talk visits as lawful, reasoning that even though the curtilage of the home is protected by the Fourth Amendment, there is an implied license to approach a residence, knock on a door, or ring a bell, and seek to contact occupants. However, the encounter is, listen carefully, it is wholly voluntary, and you, as an individual, you're under no obligation to speak with any government agent on this situation. Indeed, you don't even need to answer or open the door in response to knock and ringing by a government agent. And if you do answer the door, you can stop speaking at any time. You also have the right to demand that government agents leave the property once the purpose of the visit is established. Government officials would not be enforcing any law or warrant in this context, and so they don't have the authority of law to remain on the property after a homeowner or resident specifically revokes the implied license to come onto the property. You do not need to yell. You do not need to become voracious in your comments. Just be polite and say, please leave my property. That's all. When the government's actions go beyond merely approaching the door and knocking, it risks violating the Fourth Amendment, which requires a warrant and probable cause of possible wrongdoing in order to search one's property. A government agent would violate the Fourth Amendment if he snooped around the premises, peered into your window, and going to other areas in search of your residence. It should be pointed out that some judges, including Supreme Court Justice Gorsuch, believe that placing, quote, no trespassing signs or taking other steps to impede access to the door is sufficient to negate any implied permission for government agents. So get a sign, put it in your front yard if you choose to, that says, please do not enter this property, you are trespassing. All right? And you do not have to give the government your permission if you don't want to. And while in theory one can refuse to speak with police or other government officials during a knock-and-talk encounter, as the courts have asserted as a justification for dismissing complaints about this police investigative tactic, the reality is far different. Indeed, it is unreasonable to suggest that individuals caught unaware of these tactics will not feel pressured in the heat of the moment to comply with the request to speak with government agents who display official credentials and are often heavily armed, let alone allow them to search your property. Even when such consent is denied, police have been known to simply handcuff the homeowner and conduct a search over his objections. And next, there is the danger inherent in these knock-and-talk encounters. Although the courts have embraced the fiction that knock-and-talks are voluntary encounters that are no different from other door-to-door canvassing, these constitutionally dubious tactics are highly intimidating confrontations meant to pressure individuals into allowing police access to your home, which then paves the way for a warrantless search of anything they want in your home. The act of going to homes and taking steps to speak with occupants is akin to the knock and talk tactic used by police, which can be fraught with danger for homeowners and government agents alike. Indeed, knock and talk policing has become a thinly veiled warrantless exercise by which citizens are coerced and intimidated into talking with heavily armed police who knock on their doors in the middle of the night. Knock and shoot policing might be more accurate, however. Knock and talks not only constitute severe violations of the privacy and security of homeowners, but the combination of aggressive and surprise employed by police is also a recipe for a violent confrontation that rarely ends well for those on the receiving end of their tactics. Just something to think about, all right? You do have rights, but you won't, if you don't know which rights you have, then you're not going to be able to use them.